Rise.
You may have seen. Okay, so the matter that brings us here today is Her Majesty the Queen and Susan Smith. May I have appearances, please?
Justices, my name is Joe Potter. This is my co-counsel Andrea McNevin, and we represent the appellant.
Good afternoon, Justices. My name is Maddie Tracy, and this is my co-counsel Justin Keynes, and we're here on behalf of the respondent, Susan Smith.
I'm not sure who's going first for the appellant, but is it Mr. Potter?
Yes.
No, then you have the podium, sir. Unless there are any preliminary matters either side would like to address?
Yes, I'd just like to raise your attention at paragraph 27 of the appellant's factum. The second sentence there, the quotation should read, risk to public safety instead of risk of public safety. I'd also like to point out that there was one case missing from the appellant, or from the book of authorities on the appellant's side. It's the case of R.N. Boudry. I have print copies here with the clerk if you'd like.
Sure, we'll hand them out. Okay.
Justices, would you like a brief recitation of the facts?
I think that's fine.
I'll be addressing the appellant's first issue. This is located at paragraph 14 of the appellant's submission. The appellant respectfully submits that the learned trial judge erred in law by finding that, in the circumstances of the case, the imposition of the mandatory minimum sentence of 120 days amounts to cruel and unusual punishment prohibited by Section 12 of the Canadian Charter of Rights and Freedom. If she was correct in finding a violation, she erred in finding that it could not be saved by a Section 1 analysis. Regarding the first issue of appeal, the appellant makes three main points. First, that an application of the factors compiled in Latimer to the circumstances of this case prove that the minimum sentence imposed on Mrs. Smith does not violate her Section 12 charter right. Second, in examining these factors, the appellant concludes that there is no distinction between Mrs. Smith's three convictions. The sentence imposed results from a combination of the gravity of the offense and its repetition and subsequent convictions. Mrs. Smith's physical condition does not detract from her ability to create dangerous situations on roadways and result in significant risk to public safety. Mrs. Smith is a repeat offender and has a habit of getting intoxicated and operating a motor vehicle. The appellant's third point on the issue is that if the court were to find a violation of Mrs. Smith's Section 12 charter right, it would be justifiable, or would be a justifiable limit under Section 1 of the charter. Turning to the first point, I'd like to address the central factors of the Latimer analysis. If you would direct your attention to paragraph 17 of the appellant's factors, this first factor involves the gravity of the offense. Operating a motor vehicle while under the influence is a serious offense. In the Supreme Court case of Burnshaw, cited at paragraph 41 of R.N. Boudry, Justice Corey describes drunk driving as the crime which causes the most significant social loss to the country in terms of death and serious injury. In the event,
Counsel, that's drunk driving a car.
The appellant submits that there is no distinction between drunk driving in a car and drunk driving in the motorized wheelchair in this case.
Well, clearly, it's a matter of common sense at least, the motor vehicle is, or motorized wheelchair is much less capable of harming other people.
The appellant submits in this case that in the event of a collision, it's clear that the greatest injury would result to Mrs. Smith where she's in a smaller vehicle. But in the event that other users of the road were to try to avoid her if she's intoxicated and swerving amongst the roadway, if a car were to say swerve to avoid her, they may run into a pedestrian and injure or kill them, or run into another vehicle, and that accident would be no less severe due to the fact that they were avoiding a smaller vehicle.
But as the respondents point out, the same could be said of a pedestrian, a drunken pedestrian walking down the roadway, and they wouldn't be subject to mandatory minimums. So it would seem clear that the fact that it's different in kind from actually causing the injury and simply causing it indirectly.
Well, the appellant would submit that the difference lies in how other users of the road operating motor vehicles would perceive Mrs. Smith in her motorized wheelchair. As a car driving down the road, seeing a motorized wheelchair, that driver would recognize the fact that they are operating on that roadway not as a pedestrian, but as another vehicle. The criminal code defines motor vehicle at section 2 under the definitions as a vehicle that is drawn, propelled, or driven by any means other than muscular power. So this would clearly include a motorized wheelchair. The court has interpreted it this way in the case of Shanahan. So we would submit that it is in fact a motor vehicle, and the danger is just as likely in the way that other vehicles would interact with that vehicle.
So you're saying that because, and I don't recall that I believe it's not contested that it's a motorized vehicle within the definition of the criminal code.
No, it's not.
So you're saying because it falls within the scope, therefore we should conclusively presume the danger is the same?
It does fall within the scope, and the appellant submits that the danger is the same, in the event that accidents caused by attempting to avoid that vehicle will be no less severe or injurious, due to the fact that the avoiding the vehicle was a smaller vehicle.
Counsel, is this a real problem? Like, is this, I'm prepared to take judicial notice that drinking and driving of a car or a boat or some other vehicle is a real problem in society. But are motorized wheelchairs, is that a real problem in society that needs to be captured in the way that you're describing?
We submit that it is, although there's a low number of cases apparently under our research that we found involving this. It could have to do with
one, isn't there? Isn't it just the one case you've?
There is the one that we found, but we would suggest that is a result of police officers not pursuing such cases, and just the nature of it, where it is slightly controversial in that it's difficult to include. But we submit that the danger is just as likely and just as serious in the event of an accident, and as such it should be encompassed by the provisions protecting against dangerous drunk driving.
If I were to take you to, so you're still on factor 1, the gravity of
That's
this,
right.
Right? And so, I looked at Latimer, and in paragraph 80 of Latimer, they talk about the character of the act. So what they talk about is the character of the action and the consequences of the offense, right? When looking at whether this is cruel and unusual punishment. And in terms of character of action, they talk about this fault requirement, right? Where's this person at fault? Because in Latimer, there's clearly a fault element there, where he planned it, he was deliberate, he knew what he was doing. Does that exist in this case? Do you have any comments on the fault element here?
Mrs. Smith is definitely at fault in that she willingly got intoxicated and willingly drove her motor vehicle home from that night. We suggest that a disabled person or an able-bodied person would be held to the same standard as planning their night for a safe way home if they're going to drink. And in that sense, there is a fault element there. Also, I'll draw your attention to a case of Mallory, where the court determines that risk of social harm is a necessary element of the offense, and in this case, or risk of public harm is a necessary element of the offense, and Mrs. Smith has made this requirement out.
She has not, or she has?
She has. The appellant submits that she has. She's created a dangerous situation.
So Mallory talks about this presumption that Mallory's the drunk driving case, right? Where Amanda Solerly says, if I'm remembering right, that the guy gets in his car just to check if the lights are on, and then goes back. And so there's a presumption as soon as he gets in his car of care and control, but as soon as he leaves the car, he rebuts that presumption.
Well, in Mallory, they determined that you need to make both care and control and a significant risk of public harm. What saved Mallory in that sense was that although he didn't intend to drive, the care and control element was slightly contested, but there was no risk to public harm or risk of danger, where he was just turning it on to check his battery and then went back into the bar. He had already had plans that night to be driven home by the bartender. And then they determined that the actual risk of danger or public harm was an essential element, and absent that, you could not secure a conviction. In this case, the appellant submits that Mrs. Smith has met that danger, met that requirement.
So the fault is the lack of planning. That's what you're saying the fault is. She should have planned ahead. If she was going to go out drinking in her motorized vehicle or wheelchair, she should have planned.
Well, the fault would be the actual commission, like the actual driving the motor vehicle while intoxicated. The way to avoid that fault would be to have planned her evening in such a way that she could have exercised her other options for getting home. First one we would submit would be to take a taxi. The second being that her husband would actually just push her wheelchair.
And are those viable? Like that was my, in reading the facts and reading your case, are those viable options? Like we're talking about is this happening in Fredericton? Does that exist? Can a person in a wheelchair take a taxi home? Is this the type of wheelchair that can be manually pushed and not be used?
It's unclear on the facts what specific type of wheelchair Mrs. Smith has. The appellant submits that it would be possible to take a taxi and that she could be helped into a taxi and the wheelchair could be placed into say a van, a taxi van or an accessible taxi, and taken over. As well, with her husband pushing the wheelchair, the appellant submits that you would be able to disengage the motorized function of the wheelchair and have that in a neutral mode where you could push it. So those would be viable options for Mrs. Smith. And in that way, she's left with multiple options, as any able-bodied person would be. You have to require and plan your night accordingly if you were to go drinking.
And what about the consequence element then? Right, again, Latimer, the consequence of his actions is the death of his daughter. What are the consequences in this?
The consequence here is the risk of danger, the risk of public harm, and the appellant admits that there is a significant risk of danger with this offense, and that a severe accident could be caused, resulting in great injury to other users of the road, specifically Mrs. Smith herself, where she's in a smaller, unprotected vehicle. I'll move on to the second factor of the Latimer test, which looks at the personal characteristics of the offender. That's located in paragraph 18 of the appellant's submission. Mrs. Smith is a repeat offender and has a habit of becoming intoxicated and driving a motor vehicle, and she poses significant risk to the public safety, as we've already established. I'll quickly move to the third factor, which is the particular circumstance of the case, in the next paragraph, paragraph 19. Here I address the fact that she did have other options. Central to this, Mrs. Smith had been convicted and twice before for the same offense. While it's unclear on the facts whether or not these offenses occurred in a car, it seems that where it was before the event of her accident and before she became paralyzed, that it would be in a traditional vehicle, say a car or a truck.
Now, on your paragraph 21, I have to come back to the question of drawing the line between the walking and the driving a motorized vehicle, and you've acknowledged that if Mr. Smith pushed it, it wouldn't fall within the criminal code. He pushed the wheelchair. Now, if Mr. Smith were drunk at the same time, because they've both gone out to the bar and had a few drinks, it's clear he would not have fallen under the criminal code offense. He might have been subject to mischief, but there'd certainly be no possibility of a mandatory minimum. And so what really is the difference between Mr. Smith drunk pushing the wheelchair home and Mrs. Smith drunk driving the wheelchair home in terms of public safety?
Well, first of all, it's unclear on the facts whether or not Mr. Smith was in fact intoxicated.
No,
but
that's the supposition is suppose
yes,
that were the case, he were intoxicated. Maybe he'd done it a few times before. This was their habit to go out, get drunk, he'd push her home.
Supposing that was the case, the appellant would submit that the nature of that, in that if he was pushing her, he would be forced to go at a slower and more cautious rate, presumably due to the nature that he's guiding a vehicle with his own muscular power. And he would be forced in that case to exercise caution. And that the criminal code has specifically delineated between offenses of driving while intoxicated and the potential offense of mischief, which would be walking while intoxicated, and is that distinction would apply in this case to different offenses.
Do we know how fast this motorized wheelchair goes?
Again, it's unclear in the facts how fast the wheelchair will go. The appellant would submit that it will go at least as fast as a person at a jog or a run, if not definitely capable of speeds faster than a slow walk.
But we don't know that.
But we do not know.
So would your submission be that if in fact the wheelchair is only capable of going at a walking pace, then what if that were true on the facts?
The appellant would submit that there is still a significant danger created in that sense, and that other vehicles would regard that vehicle as a vehicle on the road and would proceed accordingly, whether or not they knew it was capable of faster speeds.
But she wasn't on the road, right? Like, if we can go back to what actually happened that evening, she's in a parking lot. Like, I agree, maybe she's a danger in that parking lot, and she could have run over someone's foot or something. But like, is there a real risk here in that parking lot that evening that she needs to go to jail for 120 days? Is that?
Well, the sentence imposed is a result of the fact that it's her third offense, and that she's exhibited the behavior of not being socially responsible in her drinking habits. And when she's out drinking, she's still driving her wheelchair and creating a danger. Now, in a parking lot, there'd be, let's say, a closing time of a bar, a lot of vehicles around. The appellant would submit that there is a significant danger in that case. With cars, on the facts, it was clear that cars had to come to an abrupt stop to avoid hitting her, and that the danger is still created.
And you don't feel like a distinction can be drawn between those first two offenses and this third offense?
No, we submit that there is no distinction, that it is a motorized vehicle. She was operating it while intoxicated, and in that sense, there is no distinction. Justices, if I could turn your attention to again, the factor 3 under the particular circumstances of the case. Just like highlight again, where there is no distinction between the offenses, the prior two and this one. It is that fact mainly in combination with the gravity of the offense that she will be subject to the mandatory minimum sentence.
I guess where I'm having trouble here, counsel, is that in theory the police could have stopped her and let her go. Right? The police could have stopped her and said, look, maybe this is why we don't see these cases. The police could have stopped her and said, look, your husband needs to push you the rest of the way home. You can't be driving around. So discretion is okay in the police's hand because they recognize that this is a woman that if she has 2 drinks or 1 drink, I don't know how much she weighs, but she automatically is impaired. Right? She's probably over the limit. But then once it gets to the sentencing judge, the discretion is